The judge overseeing Trump's election interference trial has also presided over dozens of trials of the January 6th rioters. In those cases, District Judge Tanya Chutkan has taken a strong stance against efforts to overturn the 2020 election. Now, all eyes are on the federal judge as she prepares to oversee this case. CNN's Randy Kay has more.
She has described the events of January 6th as a violent mob seeking to overthrow the lawfully elected government. District Judge Tanya Chutkan has a reputation as someone who hands down harsh sentences, specifically in cases related to the January 6th rioters.
She's talked about 2024 and the threat that these rioters pose before, during sentences.
As a federal judge in D.C., Chutkan has presided over dozens of criminal cases against alleged January 6th rioters. She has often been outspoken at their sentencing hearings. At a January 22 sentencing hearing for two friends who had gone to the Capitol, Chutkan said, "This wasn't Bill and Ted's excellent adventure." She added, "They came to Washington knowing full well the events of January 6th. Their actions were an assault on the American people." She also called it a violent attempted overthrow of the government that almost succeeded. At the criminal sentencing of another rioter, she said this.
He did not go to the U.S. Capitol out of any love for our country. He went for one man. One man in that sentence would be Donald Trump.
This won't be the first time Chutkan has dealt with a case involving the former president. In November 2021, Chutkan rejected Trump's efforts to block the House Select Committee investigating January 6th from accessing more than 700 pages of records from the White House. In her ruling in that case, she wrote this memorable line: "Presidents are not kings, and plaintiff is not president." Chutkan has called the January 6th violence an assault on American democracy, saying rioters soiled and defaced the halls of the Capitol and showed their contempt for the rule of law. She's repeatedly gone above what prosecutors have requested for convicted rioters' prison sentences. Chutkan has also issued a warning about future political violence at a sentencing hearing in December 2021. It has to be made clear that trying to stop the peaceful transition of power, assaulting law enforcement, is going to be met with certain punishment.
Is bedrock.
Chutkan was born in Kingston, Jamaica. She was appointed by Barack Obama in 2014 and has served as a federal judge since the Senate confirmed her 95-0. Before that, she spent more than a decade working as a public defender after graduating from the University of Pennsylvania Law School. Randy Kay, CNN.
All right, a fascinating look there. Thank you, Randy. Let's bring in former federal prosecutor and author of A Spy in Plain Sight, Lise Wheel. Good morning to you. Thank you so much for joining us. So we know that the next hearing is set for August 28th, where the judge is expected to schedule a trial date. And, we know that the prosecution is pushing for a speedy trial. Trump's defense counsel wants more time, and perhaps they'll try to delay through or past the 2024 election. Will Trump's other cases factor into setting a trial date, and what kind of timeline do you expect here?
Perhaps they may factor into it. I expect a fast track, a rocket docket even. But the judge is going to have to consider the other federal case going on in Mar-a-Lago in Florida, which is now set for May. She may want to postpone it until, say, June, July. But on the other hand, if the prosecutors are ready to go, there's only one defendant here, not multiple defendants as there are in the Florida case. This may be a faster case to docket. And last I looked at the criminal justice statute, the speedy trial statute, there's nothing in it that's an exemption for defendants that are too busy or running for president. So it will be set at that August hearing date.
Why would this be a faster case to docket? Do you see this as a much stronger case for the prosecution?
It's not even that, although I do, because this is a much more commonsensical case. We get it, right? I mean, someone's not happy with their election results while in office, and they try to overturn that. That makes common sense. I mean, bad common sense, but it makes more common sense than, what are these documents? Was he supposed to have them? Was he not supposed to have them? What was his intent? It's a harder case. But I say that it's a rocket docket, not so much because the prosecution has a stronger case or a more commonsensical case, but just because there's only one defendant. So the judge doesn't have to look at different schedules and whether all the defendants go together or the co-conspirators go together. This is just one person in this indictment. Yes, there are unindicted co-conspirators, but that doesn't matter. So she can set this early. The prosecution's going to be ready. The discovery's going to be ready. Hey, the discovery's pretty much right there in the indictment. It's a 45-page indictment. So the prosecution is ready to hand all that over to the defense. And then at that point, the defense is just going to have to say, we need more time. But for what? Once they've been given the materials, they have a reasonable time, but not an extraordinary amount of time, Amara.
We're already seeing one of Trump's attorneys making his rounds on TV arguing that Trump is protected by the First Amendment. Listen to what part of what John Lauro had to say on Thursday.
I've talked a lot about how this is criminalized First Amendment speech because President Trump, like all of us, has a right to redress grievances, has a right to protest an election that he felt was unfair, has a right to campaign on a position. And they've attacked that right, not just for President Trump, but for everyone.
Lise, do you expect the defense during this particular defense during trial, or is this just for the court of public opinion? I mean, what would the best defense be?
Oh, no, that's absolutely going to be a theme. And by the way, is that lawyer reading from Jack Smith's indictment? Because he says that right in the indictment. He says, Trump has the right to say, I'm angry, I don't like this, whatever. That's our First Amendment right. That's right there in the indictment. But what Smith says, though, is Trump went beyond that, right, in trying to orchestrate the overthrow, basically, of the election. And you can't do that. I mean, any fifth grader knows that. So, of course he's going to use that. That's going to be a theme. I think the more prevalent theme, should this go to trial before the election, which is, of course, what they're trying to not have happen, defense lawyers, is going to be a jury nullification. In other words, hey, jury, you've heard all of this, you've heard all of the evidence, but vote with your heart. Let the man go. Don't vote with the evidence. Jury nullification, is going to be a common theme along with the First Amendment.
38 Democratic lawmakers are appealing to the federal judge who's going to oversee this case, asking the trial to be televised despite rules prohibiting that. But judges can make decisions on this. This is what the letter reads in part, quote, given the historic nature of the charges brought forth in these cases, it's hard to imagine a more powerful circumstance for televised proceedings. Our CNN team was in the courtroom yesterday. Evan Perez joins us now. Evan, good morning. The next hearing is soon. August 28th, and that is when the judge who's going to oversee the whole trial is going to set a trial date, right?
That's right. Poppy, the judge, Tanya Chutkan, has already signaled that come August 28th, she wants to set a hearing. She's given the Trump team and the prosecution 7 days each for them to brief and provide information for their preferences, and then she will set a date, and that is really fast. For instance, in Miami, where the former president is also facing charges related to the Mar-a-Lago classified documents, we spent a month just waiting for Walt Nauta, his co-defendant, to be arraigned. And so you can see that this is a court that we've seen this repeatedly in the January 6 cases. We've seen these judges set quick trial dates. They want to try to adjudicate these cases, and they say one reason for that is because they believe that these people should face justice. Everybody involved in January 6 should face justice before the next election and try to prevent that from happening again in the next one. And so what we anticipate is, as you heard there from John Lauro, the former president's attorney, we expect that he is going to raise a lot of issues. He already raised them in court yesterday. He said this is a very complicated case. He believes that we have a lot of issues that have to be litigated. He also pointed out that the special counsels had 2.5 years to investigate this matter, and that they're going to have a lot of discovery to go through before they can even get ready to trial. He's raised the possibility that this could take, and this could be a 9 to 12 month trial. Of course, The judge will make the final decision with the understanding, of course, that they want to make sure the former president has a fair trial. Yesterday in court, I'll tell you briefly, he sat there, he seemed not very pleased about something that was given to him, some of the paperwork that was given to him. He and Jack Smith had clear sights on each other. Several times they looked at each other, which is very different from the previous proceeding in Miami, where they could not really have straight sight lines at each other. Poppy?
That's
Phil?
really interesting. So few people get to be in the courtroom, and you were there, you got to see all of that.